Good evening, folks. When I saw this excerpt of the Nikolas Cruz trial, specifically this excerpt wherein defense counsel says something entirely inappropriate to the judge and gets himself essentially kicked out of the courtroom, had to give my thoughts and comments on the video. So just to set the stage a little bit in terms of what the situation was, before we get into the craziness, this was uh, this was an objection by defense counsel, specifically with respect to victim impact statements and some concern about some inappropriate statements that might have been made by the families of the deceased children that they indicate were inappropriate and raise some security concerns on the part of the defense attorney. Specifically, some concerns regarding the fact that they had made reference to defense counsel's children, and thus that's the nature of their objection and how this issue came to be to begin with. I'll let you listen into the rest to hear kind of the exchange between the judge and the defense attorney, which ultimately leads to the defense attorney getting removed from the bench.
I listen. I've already heard. If you have anything else to say, you can put it in writing at a later time. I've heard from both sides more than once. That's going to be it. I've made my decision. Like I said, 99% of what's been testified to has been appropriate. I do not want to highlight the few things that were said that were perhaps not appropriate, and let's move on.
Judge, I'm asking for 20 seconds next.
You can have as many seconds as you want in writing, and you can put all of your objections.
So, first issue here. She's already made a ruling that even though there might have been a few things that were bordering on inappropriate, that basically she's not going to listen to any more of their speaking objections, and that if the defense counsel wants to raise a written motion, they should do so. So she's already made that ruling, and one of the first things you learn in court, and if anybody's been to court, you probably know this, is that when the judge has made a ruling against you, there comes a point when you need to make the decision to just stop arguing. Like you've made your point, it's been rejected, you disagree, you've said what you needed to say on the record. It's time for you to kind of move on and get on with your life. And in this case, especially too, if you're defense counsel, the point has been made, you've lost the point. Time for you, okay, you want to write a written brief, you want to preserve it on appeal, you want to, make known whatever it is you need to make known. That's fine, do it at another time. This defense attorney, unfortunately, does not agree with this and did not get the memo. And here's how he ends up responding to what the judge had to say here.
Objections in writing. They've been made multiple times from your chief assistant, from Ms. McNeil, and I don't want to hear anything else. I've already heard it. Is there something that has not already been argued? Okay, exactly what is it?
Judge, before Mr. Schachter took the podium and testified before this court, I wanted to reflect that both Mr. Marcus and Mr. Satz looked at the statement prior to the reading. And so their implicit adoption of what he was saying, this improper arguments, in the court should chastise.
Okay, but what you are doing right now is highlighting something and making more of a spectacle. So if your office in general does not want to facilitate or incite violence, then we need to just sit down and move on. That's it. There were 18.
Yeah, that's another thing too. I never understood about this particular argument. It never really made sense to me. The idea that the prosecutor, by allowing victim impact statements and some of the, again, like the judge said, I don't really know how much of the statements, like what percentage was really be considered a legal aspect inappropriate. But the fact that they're trying to say that the prosecutor's office implicitly adopted some of the more, borderline statements that might have been made referencing defense attorneys' families. I don't think that was a good argument to begin with. And clearly at this point, the judge has ruled on this motion already. She's getting agitated. Now would be the time for this attorney to go and shut his mouth and realize that nothing you say at this point is going to help you. This is not going to end well for you. And now is the time where you have made your point. It's not going to work. now is the time to now's the time to be silent. Like, we're all for it. You advocate on behalf of your client. You make your arguments to the best of your ability. But there comes a point when the argument has reached its end. And clearly you hear the judge is getting more and more frustrated. Now it's time for this argument to cease. Will that argument cease? What do you think?
18 witnesses, 16 or 18 witnesses that testified today. There was nothing that was said until Ms. McNeil made her point made, and, you know, we're moving on.
But is the court going to do anything about maybe stopping it from happening again?
When these people are upset about specific things that have gone on from that table, like shooting the middle finger up at this court and laughing and joking, Ms. McNeil, be quiet.
So, okay. We haven't even gotten to the bad part yet. And this Miss McNeil was an individual. She already had a motion earlier that's not even in this video. She made the same type of argument that was dismissed. And there was some other sort of shenanigans that were happening at defense counsel table when they didn't agree with the rulings of the court, where basically it's, I mean, this is borderline, this is like the type of conduct you get sanctioned for when you do things like this. And first off, it's bad enough the judge is clearly mad. And then this attorney is going to go and make some type of noise, some type of laugh, just at this point, if you're at defense counsel table, now is the time to be quiet and really, again, you may not agree with what the judge has to say. If you're ever in this position, it doesn't take being an expert in really anything like this to know that when you're at this position, if you're going to do anything to disrespect the court and show up the court, it's not going to end well. And this person already has a history of, she's she's made arguments that the judge has been angry about. There was some shenanigans at defense counsel table. The judge is basically at the point where she's had enough of the shenanigans, and thus, now's not the time to really be laughing or, doing anything like what that one attorney was doing, and it only gets worse from here.
When these people have sat in this courtroom and watched this behavior from that table, and they want to say that they're not happy about it, what is the problem?
Judge, I have no problem because I have thick skin. But once you bring in my children, I think that's highly improper. And it's
I didn't even know you have children. I don't know what you're talking about. Your children? What about your children?
For them to comment on my children is highly improper. And for this court to allow that kind of testimony is also improper. I don't remember any comments about any children. And if there was, it obviously didn't, it came and went without me noticing it. Judge, I can assure you that if they were talking about your children, you would definitely notice it.
You need to...
Okay. Wait a minute. In case you missed it, I'll back up a little. This individual, basically, this counsel, God rest his soul, because he's going a little out there now. He basically says to the judge, well, Judge, the comments were inappropriate where the victims are going and referencing my children. That goes too far, which may or may not be a legitimate argument. I mean, again, I don't think any of the victims really went up there and said, I hope your children die in a fire. I mean, it was more like there were a lot of issues with how defense counsel was acting through the case the victims weren't happy about, and they referenced their children who, died in this horrible mass shooting. That's what they were referencing when it came to this attorney's children. So this attorney makes the argument that, well, it was inappropriate when they referenced the children. The judge goes and says, well, I don't even know what you're talking about. I don't even recall a situation where anybody even referenced your children. Like, I didn't even know you had kids. So how should the professional attorney and really anybody in court react to hearing that? Reminding the judge about the fact that his children were referenced, maybe making his argument on the record, saying for one last time that he thought it was inappropriate and that's why he's, raising this argument? Or do you want to go full sicko mode, full Looney Tune mode, and tell the judge, Judge, in fact, if they were talking about your children, I'm sure you would have heard her. So here's the thing, and we'll get into it. In a minute. This guy's basically insulting the judge and tried to sneak in a little sort of dig at the judge by saying, well, Your Honor, if they were talking about your children, I think you would have heard what they said. If anybody thinks that criticizing a judge in this way is a good idea, and that you're going to be clever, and this is sort of you're going to be able to get away with stuff like this, you're not going to be able to do it, and this guy is not going to be able to get away with it either, because the judge rightfully reacts as you'd expect.
Sit down right now. You're out of line.
That's completely out of line. That's completely out of line, disrespectful to the court, entirely unacceptable conduct. That's the type of conduct that gets you sanctioned. That's the type of conduct that gets you thrown out, and sure enough.
In fact, you're excused. You need to go sit in the back with your chief public defender.
He's the public defender.
Now, again, this guy really needs to just be quiet, and he's just not being quiet, and he's just continuing to risk, action being taken against him by continuing to speak. So that's not good for him.
Mr. Weeks, please ask the lawyer from your office to go sit down and not say anything else. To try to threaten my children and bring up my children is inappropriate. Go to the back of the room now.
Okay, one thing in the attorney's defense specifically, though, this is one thing I want to mention. He wasn't threatening the judge's children. That, I think she misconstrued that a bit, even though she had every right to be angry, and he definitely deserves to be thrown out of the, what he did was entirely disrespectful and just not really the sort of professional behavior you're supposed to show in court. I will say that he was not threatening her children. He wasn't making an implicit threat to the children. Specifically, he was just trying to get in a little sarcastic dig about the judge's attentiveness by saying, well, if they mentioned your children, you would have been paying attention, basically. So that is one thing I disagree with the judge here. He wasn't threatening her children. That was incorrect. But at the same time, definitely deserved to be sent to the back of the room in this particular instance.
That just violated about every rule of professional responsibility that I have never. If you're going to get up here and you're going to...
Judge, I asked you to go sidebar on this matter.
You, sidebar or not, you don't have one of your assistant public defenders say something about my children?
Judge, that same venom that the court is expressing is the same venom that defense counsel had to sit through this entire morning when their children
She brought up her children multiple times during the trial. Nobody knows if I'm barren or not. They don't know about my children.
Judge.
Sit down. Sit down.
Judge.
Sit down.
Now, see, here's where, and I get what the defense attorney's trying to do, and I like I said, I don't know this guy personally. I get what he's trying to do. He's trying to defend his colleague there, even though there was really what he did was inappropriate. If it were me, I would have gone and maybe just said for the record, Your Honor, just for the record, I don't believe the statement he made was in any way intended to be a threat towards your children or anything like that. Now, again, it's kind of hard because do you want to go and basically throw your colleague under the bus and admit that, no, he was just insulting the fact that you were unattentive? I mean, he's kind of in a tough position there. And I guess he tried to do the best way he could was to go and say, well, Judge, you're mad because we referenced your children, but literally, according to the defense, their victim impact statements have been referencing our children the whole day, and you've done nothing to stop it. But at the same time, I mean, at this point, the judge is so infuriated, and really rightfully so for the disrespectful nature of what defense counsel did. There's kind of nothing really to do at this point than sort of just take the verbal abuse that you're going to get from the judge, because you're not going to win this motion. You're not going to win this argument. And, you know, a supervisor does have, you know, I mean, some credit to him for trying to defend his subordinate. Like, I get it. But at the same time, what the guy did, being disrespectful to the court in that way, is never a good idea, and is never going to really be a successful sort of way to conduct yourself.
Down, Mr. Weeks.
Please do not summarily dismiss me.
I'm summarily dismissing
I'm asking
you.
the
Go
court.
sit down.
I'm asking the court. I asked the court to go sidebar.
Go sit down. You don't threaten the
Judge,
court's children.
everyone
Your
in this
assistant just
courtroom-
did that. Go sit down.
No one in this courtroom had to endure what we had to
Go
endure.
sit down.
Now, see, that's where he should have brought up the argument, Your Honor. What my colleague did was in no way a threat to the judge's children. That I do not believe that that's what he was trying to do. But his argument, here's where I don't agree, arguing that you wanted to go into a sidebar, and, you know, now you're not going to be successful. And that's what surprised me really about this clip specifically, is that if I was the attorney, I would have gone and said, Your Honor, I don't believe that counsel was, and again, it's hard to really defend the indefensible, but, you know, sometimes if you're an attorney, you need to do that. Sometimes, you know, parents have done it. Like, sometimes you defend indefensible conduct. And if I was his supervisor in this, first of all, if I were his supervisor in this case, he probably wouldn't have a job after this regardless. He would be looking for employment somewhere else. But in addition to that, I would have gone to the judge and said, Your Honor, I understand your ruling. The only point that I would make is that I don't believe the colleague was saying anything with respect to any threat with respect to your children. I think he was commenting on the fact that I think he made an inappropriate comment that was disrespectful to the court, and, you know, like, whatever you want to say in the alternative. But I think the point should have been made that I don't think counsel was trying to implicitly threaten the judge's children. That I disagree with. But the rest, entirely inappropriate, disrespectful, and certainly this, you know, this is not helping the matter.
Ms. McNeil has made her children a spectacle more than once during this trial. That was her choice. You have absolutely no right to have one of your assistants come up here and suggest something about my children. Now, please go sit down.
Judge.
You're inappropriate and out of line. Go sit down.
Judge, may I have a brief recess?
No. Go sit down.
May I have a brief recess so I can speak to my attorneys?
We're moving on with the sentencing, Mr. Weeks.
So can I have a brief recess?
No.
Thank you.
It's 1:36. Thank you.
Yeah, and, you know, so that's the end of that. But yeah, in conclusion, definitely one of the takeaways from this particular video is that when you're in court, there are going to be times in court that you're going to lose, and especially, as you can see, the public defenders, they've basically been given an impossible task to go and defend the indefensible. I think everybody could agree on that. But at the same time, not only were a lot of the tactics and actions that they took really entirely inappropriate, but also, too, when it comes to the point when you're losing a motion like this, there are going to be things where a court's going to disagree with you. And while there's a time to, of course, you have a right and a responsibility to engage in a vigorous defense, there comes to the point where the argument's been granted against you, the motion is over, you've made your point, your objections are noted, and then it's really time for you to kind of go, accept the fact that the judge has ruled against you, and sort of move on from there. So this was a big mistake by defense counsel that had done a lot of things wrong. Not something I'd normally put a video out on, but I saw it online, figured I had to comment on it just because of the nature of the case, and just to give give my thoughts in terms of if you're ever in this position where you're brought into court like this, and obviously I'm not talking about for something, as heinous as the crime that, this Nikolas Cruz guy was, found guilty of. But anything in general, even if it's the smallest type case, you need to understand that when you go to the court and the judge is expecting a certain modicum of respect. And if you think you're going to be clever and make comments like that attorney did, where, oh well, if it was your children, you would have, heard what they were saying, as if like the judge just didn't really care. Like, if you're going to do stuff like that, you're going to get reamed out. You're going to get tossed out of court. You're going to lose your case. So that's the takeaway. Hope you enjoyed the video. Thanks for your time.